Today is April 8, 2026, and it is 4:20 a.m. U.S. Central Time. My name is Rinaldo J. Aguiar Marcano, and this is the second part of the declaration D132, so 132. And for today, what I would like to do is to continue with the previous part, which was about the escalation, really bidirectional, right? They started it and then I responded. That started around March 25th. And until the point I recorded the last demo, which I think it was April 4th, I mean the first part of this declaration. So that was what we covered, right? And I described the series of steps that I took. It was basically a structured strategy. It is a structured strategy that I'm employing to expose them, right? To make it obvious what they're doing. So that's where we left. And in that train of thought, or in that series of steps, I think we landed on step 12, if I recall correctly, which I think was KKC. I mean, at that point, KKC, that intellectual property law firm, was the conductor of the train that I described, right? The locomotive. But I think sorry, 1 second. Yes, so that's where we left, right? No, and I think actually the last step we talked about was actually Terrell Miller, right, from Lake Point Estates, and he's that intellectual property attorney who is a partner at Foley.com, that intellectual property law firm. So that's where we left off. So now I'm going to tell you a little bit about what's the next step, what happened after. We'll take it from there. So before I do that, let me tell you something interesting here. Yes. So I wanna make a pause here for a second. I'm gonna give you some patent application numbers. These are patent applications that I filed with the United States Trademark and Patent Office. And I'm going to give you the numbers and what they are about because, I mean, they're going to be very relevant to this conversation, and I don't want them to get lost at the end of the demo. Like, these are very important applications, I believe. So, and I have them kind of sorted by how disruptive they will be. So the first one is, and the format of these patent application numbers is a number with a slash and a comma. It's a kind of a weird format that the USPTO office uses. So the first one is 19/640, 945, and this is a new encryption method that I invented. The next patent application number is 19/639, 219. And this is a new CPU, a new central processing unit I invented. The architecture for it. And the next one is 19/639, 265. And this is a high radix parametric satellite communication system. And the next one I'm going to talk about is 19/639, 255. And this is a high radix parametric cellular communication system. These are 5 out of the 50 that I have filed, but I think, all of them, many of them, most of them are going to be very disruptive, but these are foundational. Like these are going to change everything. And Don't take my word for it, right? Like show these patent applications to somebody that you trust that know about these technical topics, and they will give you their opinion, right? Like don't trust me, trust somebody that you already trust. Um, so I wanted to make that pause before we continue. So now I have to tell you on the step 12 where we left, right? Terrell Miller. Um, yeah, it's interesting because I mean I discovered this after I recorded that part of this declaration. That law firm, Foley.com, they are one of the um, most commonly used intellectual property firms. They're an intellectual property firm, right? And they're one of the most commonly used by a couple of companies. One is Huawei, right? Like this Chinese telecommunication company that I think one of the top executives was even charged with espionage recently, not too long ago, right? So this company, put that in perspective, right? Well, and the other company is, I think it was, don't quote me on this one, but I think it was Lockheed Martin, the defense contractor that has that huge headquarters in California, in Sunnyvale, in front of the Yahoo headquarters. And I know this because I used to drive in front of that headquarters every day. Um, so, uh, but put this in perspective, right? So Terrell Miller, right, who is an intellectual property attorney and a partner at this law firm, leaves that represents these two controversial companies. And they're controversial, well, one, because the executive of the company have been charged with espionage. I'm talking about Huawei, right? They manufacture telecom equipment for cellular carriers and for other type of companies. And then Lockheed Martin, right, which is in the defense industry, which is sensitive. So this intellectual property attorney that works supposedly, right, in the intellectual property of these companies, lives in front of Robert Mueller, who was a former, who was the director of the FBI several years ago. I mean, and not only that, but Terrell Miller's house is marked in the geo index in the database that was leaked by the Venezuelan intelligence to me in 2024, and you can check this out in the website. So I mean, it's a super. I mean, it's obvious, right? It's obvious the role of Terrell Miller in all this, um, and it's obvious also that how important he is for this network, right? And what they're doing. Um, but this realization led to a series of, led to a discovery that is really powerful. That I didn't know about this, right? But when I saw this, I started looking into it, and it seems to be a thing, right? But I'm going to give you the observation. But I think, of course, it would be the role of the authorities to investigate this, right? Like I don't have the resources or the reach or the access to see if, well, first of all, to verify this, and secondly, to see the extent of the involvement, right, of these individuals. But it seems that to this point, it seems obvious to me that this is what they're doing. So I'm going to tell you what I've noticed. So in this law firm, Foley.com, one of the partners that work with Terrell Miller is somebody, his name is, let me stop here for a second to give you the name, because it is important. One second. I have it noted here somewhere. Uh, just one second. No, the name escapes me. I don't have it with me. I don't have it in my notes. But he's a gentleman by the name Tisao. I mean, the name sounds Chinese, right? And he's also a partner in this. Oh, I think I mentioned him in the previous segment, right? Like, he is interesting because he was an employee of the DOJ. Right? I mean, he's a former DOJ official, and he was a litigator there for 5 years. And then now he's the partner of this intellectual property firm working for Huawei, right? And he's Chinese. I mean, it's a lot. It's a lot of red flags to me. I mean, I'm saying this. It's not a racist comment or anything, but like I've been working on this problem for a long time. So when I see all these coincidences and the way they've been obstructing justice with in the DOJ and in other places, it's it's kind of something that caught my eye, right? So I started investigating or researching intellectual property firms because I know the intellectual property firms are. I mean, at this point, until this started, for a few days ago, I knew already that the intellectual property firms are an important part of this network for obvious reasons, right? Because what the Chinese are doing is stealing intellectual property, and they need to defend against the lawsuits, right? So they can't leave that open. But I didn't know the extent of the involvement of the intellectual property authorities, right? But anyhow, when I saw that the Red Miller, who has this $4 million house 300 feet away from the property my company has at Lake Point Estates, and I see this gentleman by the name Tisao, and that he worked for the DOJ, it occurred to me to investigate of these prominent intellectual property firms that primarily do work for the tech companies of this RICO enterprise, which we have talked about before. Out of that set of intellectual property firms, it occurs to me to look into how many, I try to identify partners that work in intellectual property that had been at the DOJ before. That's how this thing started. When I started doing this, immediately I noticed a statistical anomaly. It's a huge number. I mean, there's a huge number of individuals in this category that meet this criteria. I mean, and the criteria is very complex, and the complexity of the criteria is important because, in statistics, the more complex the criteria, the lower the probability that somebody will meet it. Right? Like if you make the criteria very, very specific, and it has many conditions, the number of individuals that will match all the conditions is smaller, right? And it gets to a point where it's, and if you find with all these very specific criteria, a lot of individuals or a high percentage of individuals in a set that match the condition, this means that there's design behind this, right? Like this cannot be random. So this is how it started, right? So the number is huge, right? So, to spare you the suspense, basically, part of, I would say that leadership of this network. I mean, it's not. I would say the second level leadership, right? Like I think there's a political aspect of this above, right, above them, but on the second level, like the vice presidents, right? If I was to put a name, the vice president committee or vice presidential committee of this network is a network of intellectual property attorneys that are partners in these firms that were previously employed by the DOJ. That's basically the definition of this RICO enterprise. And this explains many things to me. Like after I saw this, the world that I'm seeing made a lot more sense. I mean, it makes sense why they partner with intelligence services. Because, I mean, if they're going to steal intellectual property in this way, using legal means, and, so they steal the intellectual property and then they patent the inventions as if they were theirs, right? Or their clients. So it makes sense, this partnership between the intellectual property attorneys and the foreign intelligence services. And of course, to make this work, it makes sense to employ former DOJ employees because, and I'm sorry to make this so hyper-local to the United States. I mean, this is a problem in other countries. Identify the same pattern. The same pattern happens in other countries. Of course, the United States is the biggest part of the problem because, and this is probably why they are so focused on the United States. It's because if you look at the market of intellectual property litigation, the biggest chunk is in the US. It's like, I don't know, I can't recall the numbers. It's like $10 billion in the US versus the next contender is China with $2 billion, something like that. So obviously, a big chunk of the inventions rights are in the United States. I'm talking about if you look at the entire planet, right? So that's why the Chinese are so concentrated in the US to steal the inventions, basically. So the name of the game is really the inventions. That is what they're after, more than anything, right? And I think this has other implications. But let's talk about that at the end, right? But so what they're doing is basically that, right? So it's a network of. So what I was telling you is that it's important to employ former DOJ officials because that's the way they obstruct justice. Like if one of the targets, like me, right, wises up and sees what's happening and tries to report them to the FBI, they will obstruct justice because they had been at the DOJ for years. And like I have to tell you, they're very high, very, very high level former officials. Like don't think that these were like just litigators. Like there's in this network, in this matching this set of characteristics that I'm describing, right? That they are former DOJ employees, and then they went out to the private practice, and specifically on the intellectual property side of things, and ended up being partners at those firms. In this group, there are people that were assistant district attorneys, people that were district attorneys before, nationwide. There's people that were I'm gonna give you some specific names, right, and some examples. But these are very high-level individuals, and what I want to tell you is that think about that, right? Like if somebody who was, the assistant district attorney for California, right, for years, then goes into this private practice and start working on IP litigation as a partner, right? If some of the targets in California figures out that Elon Musk or Travis Kalanick or Piero Midyar, of those people stole their invention and they go to the FBI, or that they have them under surveillance and go to the FBI, this person will call somebody at the FBI and because this person was super high up and for years, right? And he must know people, right? This institutional knowledge is taken from the DOJ and then put to work for the Chinese in this way. That's basically the TTP. And that institutional knowledge is important. And I don't know, like I've never worked at the DOJ, and I'm not even an attorney. But I imagine, right? This is powerful. Like I don't know, I'm trying to see this in my own experience, right? My own working experience. Like for example, when I was at Google, and I left Google 8 years ago, right? But if you ask me today, right? If you have a conversation with me today and you bring to me a problem that you have with a Google product, for example, right? Whatever it is, Google Drive, Google Cloud, Gmail, whatever it is, right? You give me a bug, I could tell you exactly who is the person that you need to talk to in Google to make this problem go away. Like I have that institutional knowledge because I spent 9 years at Google, right? So I imagine it's the same with these people. And at Google, I wasn't very high up. I was a staff engineer, but I wasn't a director, right? But I imagine it's like employing, like if you employ somebody who was a principal engineer at Google or senior director at Google, that person would have a lot of institutional knowledge about who to talk to make a problem go away. So that's why this is important, right? Because it's a tool to obstruct justice. So the targets cannot complain to anybody. That's the idea. And they have a list of people that are very very high up. That were very high up in that federal, law enforcement / Justice Department world. But are now working on these intellectual property firms as partners, right? So this is an statistical anomaly because it is not possible that in all these firms, I could not find one firm, let's put it this way, I could not find one firm of these prominent firms that work for, the PayPal mafia companies, let's call them that way to simplify, that do not have multiple partners in the firm that were former DOJ officials. I couldn't find one. Okay, but that's not all. Also, if you look at BlackRock, right, which is the monopoly aggregator of all this, they have some of the most powerful people. I mean, not them directly, but the firms that work for BlackRock directly. There's one that is called Kirkland, for example, or I'll give you the names in a second. But they have some of the most powerful former, um, how do you call this? Former DOJ officials, right? I mean, the ones that were the higher up and the highest concentration is on the firms that work for BlackRock and Vanguard and State Street. So this tells you that this shows you that this is a TTP, right? And it's not only a TTP. The amount of people that you have that are former DOJ officials and how high they were is also something that could be used as a signal for ranking these entities in the network. I mean, if you work the problem backwards, right? Like now that you have the observation, and you know that the highest concentration and the highest power, firepower in a way, right, is on the ones that work directly for BlackRock. You know how to find the important companies, right? Like by looking at where the DOJ alumni are working in these intellectual property firms as partners. That's basically the same. So that's part of it, right? So I have a list of notable individuals that fit these very specific criteria, and I'm going to give it to you, but I'm going to do that at the end of this subsegment to not get the conversation derailed, right? With names and things like that. But if you're interested in the names, fast forward a little bit until you find that part, and you'll get the names. But now I'm going to transition a little bit more to what happened after I realized this, because remember, I have this set of patent applications that at this point there are 50 of them. They're published, right? Like I filed the applications with the USPTO. I published the applications in a book, in a printed book, and I've been sending those applications to multiple people. The patent applications to disclose that I created these inventions, right? To create a record of the inventions. So the Chinese cannot say that they invented this, right? Because I already know, the informant already told me that they're working on implementing these things to claim that they got there first, right? But this is not true. I have the timestamp applications, right? And, I have all these espionage that they're doing documented. And I'm sure probably the FBI is watching, right? Or somebody must be watching all this spectacle, right? So when they make that claim, it's going to backfire. Because it's just going to prove that they were spying, right, all this time. So anyhow, that's the... So I have the book and those things. But, when I realized that the RICO enterprise is really the intellectual property theft, right? I mean, I thought the intellectual property, I knew it was an important part because I've been a target of it for 25 years, but I didn't know how important it was, right? I didn't understand the importance of this part of this criminal network. Like if you think of any company, right? Even if it's not criminal, they have different revenue streams, right? Like, they could have different products, they could have services, they could have, professional services, etc. Right? And if you look at the distribution of where the money is coming from, it will have a certain shape, right? What I'm saying is that I didn't understand how important this revenue stream for this criminal network is, and it's very important. It's probably one of the most important. That's why the intellectual property attorneys are a big, leadership part of this. Like they are the ones running this thing, at least in the, in that high up tier that I'm describing. There is a political aspect, right? Of course, there are international political actors that are putting the money and organizing this, and putting the intelligence services to work for them. But this coalition between intellectual property attorneys and intelligence services is, in a way, directed by the theft of the intellectual property. So I want to give you some numbers, right? So I was doing some research, and if you, I don't agree with these numbers of this. I mean, I did this research based on numbers that are available from people that have studied these things, right? I have to tell you, I have reservations about the actual numbers. I think they're too low. But this is what the official, I mean, not official, but like the numbers that are out there in the public corpus of research say that if you put all the intellectual property together, like all the intellectual property that it exists in the world, right? If you put it together and you buy it, I mean, there's a caveat to this, right? Because if you try to buy all the intellectual property, there's going to be inflation, and then the prices will go to infinite. But take that away for a second, and if you buy it all, like what I want to try to tell you is the value of the intellectual property, right? The monetary value. You could, according to these numbers that I saw, you could say it's around $40 trillion. To put this in perspective, the entire GDP of the United States, which is arguably the biggest economy in the planet, is $28 trillion. So what I'm telling you is that the value of the intellectual property worldwide, according to these metrics that some people have computed, could be estimated to be around 2 times the GDP of the largest economy in the planet. So imagine the amount of value that there is in this, right? This is what this tells you. That there is a lot of value in this, right? And of course, this is what they're siphoning, right? This is why they have this RICO enterprise, because they're getting all this value. Basically, they are monopolizing all the patents, right? Through the aggregators like, Vanguard, and I mean through the companies that are controlled through the aggregators like Vanguard, BlackRock, and State Street. So that's basically the entire dynamic of the enterprise, right? Basically, to give you the entire enterprise, that the way it works is they get the money from the 401k plans from investors in the stock market. Then these three companies, Vanguard, State Street, and BlackRock, acting as aggregators of all that capital by voting shares on companies, public companies. And I mean, they probably do the same with the private equity firms, right? But let's only talk about the aggregators. So they buy shares, voting shares, and with those voting shares, they control the public companies, right? And then the public companies are the aggregators of the patents. So it's a two-level aggregation system, right? It's a financial aggregation at the beginning to control the public companies, and then the public companies themselves are aggregators of intellectual property. And this is intellectual property that they're stealing using the intelligence services of all these coalition of countries that they have, right? It's Russia, China, Venezuela, Iran, Cuba. So they steal intellectual property, they patent it, right? And then the public companies own the intellectual property, but then they are controlled by Vanguard, State Street, and BlackRock because they can replace the CEO and the CFO at any time in the ways that I described in the previous segment of this declaration. So that's basically how it works. So when I saw this, it all made sense to me. I mean, the things that I've been experiencing for the last 25 years. I mean, the world made sense to me. I understand. But this is where things got really interesting because, remember, I have that patent portfolio of 50 inventions that are going to be disruptive. And I know this, again, I mentioned this in Demo 130. I'm not speculating here. I know this because I get the gossip from the Venezuelan informant that works in the Venezuelan Army Intelligence. And he already told me multiple times how desperate they are when they see these patents. And when I file new patents, they go, they're like, he described the feeling that they get when they see that I'm filing a new patent application. Okay. 1 second. I'm gonna make it. One second. I need to. So so yes. So and the reason I'm mentioning the patent applications is because I mean this makes it so that it's a perfect weapon for me in the sense that um, I mean if the RICO enterprise is directed by the intellectual property attorneys and I have a portfolio that it's going to be so disruptive, and again I know this because I get the gossip from the informant. Well, I can use that as a weapon, right? I mean, I can start putting them on notice. I mean, not only the companies, but the intellectual property attorneys themselves who are running the RICO enterprise. I can put them on notice of the patent application that I filed, and this gives them a legal obligation to respond. This makes all this evidence get into their systems, into their internal systems, and they can destroy the evidence because that's a federal crime. Um, and if they don't respond, I mean, they have two choices, right? So they can respond. If they respond, then I send them a notice that says notice to the agent is notice to the company, right? Notice, I mean, notice to the agent is notice to the party, right? Meaning, if one of these companies replies to me, then that makes it so that automatically the public company that or the public companies plural that they represent are deemed to be in notice of the inventions, and that opens them to immense commercial liability to me because I can sue them now, right? They were on notice of these inventions, and if they don't reply to me, then this shows collusion. They shows that they're acting as a RICO enterprise. I'm talking about the intellectual property attorney. So they have to choose between sacrificing the public companies and giving me the rights over the inventions, or confessing basically by their inaction, collective inaction, that they are a RICO enterprise. I mean, I'm talking about the intellectual property authority. So this is nuclear, it's checkmate. Like they have no escape from this. And this is why I started by giving you the the patent application numbers that I gave you at the beginning, because those are the four more fundamental two reasons, right? So those are the most foundational patent applications within the set of 50. In the sense that they're going to be, I mean, they're foundational to disrupting. I mean, what I mean is they're gonna be important for disrupting what is foundational today in the technology stack that we have in the world. I'm talking about the Intel processors, the NVIDIA chips, uh, the the internet itself, the way it works, is going to be affected by these patents. And the most important, or most, I wouldn't say most important, but like the broadest application patent here is the encryption patent, the first one I gave you, because everything uses encryption, and this is a new encryption method that I invented, that it's superior and it's basically unbreakable. And again, I'm not, I'm not speculating here. I know it's unbreakable because this is exactly, I mean, I invented this method of encryption to be able to survive this against the CCP. This is the way I encrypt my messages, and they're not able to decrypt them. They haven't been able to decrypt one message I've sent to multiple people, right? Or one message that I've received from multiple people. Over a period of, I don't know, I've been using this system exclusively for encryption at least for a year at this point, right? And they haven't gotten one of my messages, and I know that because the informant told me, right, that they don't know, they didn't know how I did it. Of course, I didn't patent this invention before. I didn't apply for the patent before because I was treating it as a, so in the patents world, there is two types of inventions, right? So you can treat it as a patent. You can try to patent it, right? Which makes it that you have to publish how you're doing, right? But if you think that it's hard to defend, or you don't want to publish it because you don't want your competitors or your adversaries to know how you're doing something, you treat it as a trade secret. Meaning you just shut up, you don't patent it, you don't publish it, and you do it secretly. So nobody knows how you're doing. Of course, if you have a spy, like the thousands that they have, this is hard to keep secret. But this one, I had chosen for a year to keep it secret. Because if I tell them how I do it, I don't know. I don't think they're gonna be able to break it, really, because logic, right? But it's possible that they may, find a way, right? So to be safe, I didn't want to publish it, right? So yes, so but when I see yesterday that, or 2 days ago, I can recall that this network, this Rico enterprise, is really a Rico enterprise composed by former DOJ officials that are partners in intellectual property firms. I said, I have to patent this because if I apply for a patent, uh, basically it gives me access to put in notice any company because every single company in the world uses encryption. So I can send this notice to any company, really. I have no limit. I can send this to anybody. And I mean, it will be a legally binding notice, right? They have to take action. So this gives me access to, in a way, I don't want to say the word attack, right? But I mean, let's say attack. This gives me an angle to legally attack all of the intellectual property firms, all of them. There is nobody safe, right? Because of this encryption patent application. Because encryption is on everything. Everything uses encryption: routers, modems, the internet, your email, your browser, the encryption certificates, the protocols, the internet protocols, uh, all the messaging applications. Everything uses encryption, right? So, and I have to tell you, I love this patent. I mean, this invention, right? Because it's, well, first of all, because it allowed me to survive, right? This thing. But secondly, because it's beautifully simple. It doesn't, anybody. I think, right? I haven't said this to a person, like explained this to a person yet, but I think, right? I mean, I read this and it's so simple. Like, you don't have to be a mathematician. You don't have to know about encryption. You don't have to. You don't have to. You don't have to be a statistician. You don't have to know about prime numbers. You don't have to know anything. But if I describe to you the process of how this encryption mechanism works, it's so simple and it only uses pure logic. So I think, right, a lot of people will see how simple this is and how powerful it is, right? So I want to give it a try. I want to tell you here how this encryption mechanism works, and also I'm going to use this as a, to anchor my even more, because I already sent this even to the European Patent Office. And of course, the USPTO already has the application, right? And it's published in my book. Like, I already established the prior art, like in, I don't know, 50 different ways. Literally, because I sent this application to multiple law firms as well. So, they cannot say that they did it, they invented it, right? But to make it even, I'm going to record it here with my own voice, how what was invention, right? So I'm going to get a little bit technical on this, okay? So in the world of encryption, the way it works, or it worked until now, is that to send an encrypted message, you basically first have to share the key. You send the key first, and then and there's different ways of sharing keys, right? But the idea is you produce a key in whatever method it is, you use that key to encrypt a message, and then you take that message. First, you send the key, right? And when the key is sent, then you establish a session, okay? And everything that goes through that session is encrypted. And then when you want to pass a message through that channel, you encrypt it with the key that for that session, and then you send the message. And because the other party already has a key, or a key that can decrypt messages that were encrypted with this key, then they can decrypt the thing, right? The message that goes through the channel. But you see, this has two problems. One, that is synchronous, meaning that you first have to send the key to be able to send the first message. And if a man in the middle intercepts the key, they will be able to decrypt anything that passes through that channel. So that is a problem, right? And also the second big problem is that there is a correlation between time and space, because time and space with the event of sharing the key or sending a message, right? Because if you share the key, the attacker, a hypothetical attacker, can see that you're sending the key, and therefore they know where you are. Right? Because if they're able to see the communication, it's because they know where you're located. I mean, I'm talking about physically or virtually, right? If it's a cell phone, well, they can see the signal of your cell phone. They know where you are. Or if it's a router, for example, that is performing the man-in-the-middle attack, or they're performing it there, then they can see the IP address of the network equipment that is communicating with the router, right? So either way, they will know, right? One second. Um, so so yes, so that's problematic, right? It makes interception very easily, very easy. So let me tell you the system I invented, right? And this is what I tell you. I think it's a beauty. I see it and I see beauty in this thing, right? And this again is how I've been doing to communicate. This is what I've been doing to communicate for almost a year at this point. I mean, on the encryption side of things. There's also another inventions that I have on the area of transport, but I'm not going to talk about those. Those I'm going to keep as trade secrets for now. But on the area of encryption, this is what I've been doing. So it is a different process. So in this system I'm going to describe, or in this method, you never send the key. So imagine that. I'm going to tell you a way in which you can encrypt a message and send it and be decryptable by another party without ever sending the key that you use to encrypt that message. Imagine what I mean. That's it's a paradigm shift, right? Completely. So this is how it works. So step number one is that you create a key. Let's call it key number one. Okay, and you encrypt the message. Okay, and you send first the message encrypted without sending the key. So this is the first paradigm shift. You are sending the message before the key. You send the message, okay? But the message is encrypted and the key has never been sent, so they cannot decrypt it, okay? Now, and this is another good property of this system, I'm telling you, it's asynchronous, meaning you don't have to do the things in a particular time frame. For example, you can send the message today and you can send the key tomorrow, or in 30 days, or in a year from now. They don't know when the actual key is going to be sent. I mean, the attacker, right? The CCP in my case. They don't know when the key is going to be sent. So they don't have a way to collide in time and space with the key because they don't know when I'm going to send it. I could send it from my home, or I could send it when I'm at Walmart, or I could send it any time, right? They don't know. So it makes it impossible for them to guess. They will have to be standing next to me 24 hours, every second of the day for the rest of my life, and they can't do that, right? Uh, so But going back to the process, right? So the first step is you send the message encrypted, and it was encrypted with key, let's call it K1, but you never send that key, okay? Second step is you encrypt another piece. You take another piece of, you produce another string. Let's call it prefix 1, okay? It's a string, it could be anything, right? It's a prefix. And you produce another string that is called a suffix, and it could be also anything. Okay, and so basically you send a message for the prefix at a different time after you have sent the message, or even before. You can send it before or after, it doesn't matter, right? But the point is that you're gonna send the encrypted message, the suffix, and the prefix at 3 different times. And this means that you could send it through 3 different channels, or at 3 different places. You don't have to be in the same place. It doesn't have to be the same channel, and it doesn't have to be at the same time, right? But you have 3 different pieces. Now, remember, the key number 1, K1, was never sent, right? So the last step of this process is that you create another key, key 2, let's call it K2, okay? And this K2 key is designed in a way that it works to decrypt the data block composed by the prefix, the message, and the suffix together. And then you send that key, the key number 2, not the key number 1. So see, this key number 2 only works to decrypt the combination of the data package that is the combination of the 3 parts, the prefix, the message, and the suffix, right? But that key, K2, does not work for any of those pieces individually, meaning the message itself cannot be decrypted with K2, with the key K2. It can only be decrypted with the key K1, which was never sent over the channel, so it's impossible to be intercepted. You see, here we successfully managed to transmit a message that is decipherable, but without transmitting the key. And the key that we did transmit cannot decrypt the message and cannot decrypt any of the other 2 pieces individually. Only if you have the 3 pieces, you can successfully decrypt this with the other key, with the key K2. So you see, it's a complete change in paradigm, and it is unbreakable because they don't know when these transmissions are going to happen, in which place, on which medium, right? You could be transmitting the message over the internet. You could be transmitting the prefix over ultrasound, and you could be transmitting the suffix over satellite, right? So I mean, they would need, a microphone, a router interceptor, and a plane, right? And have these three man-in-the-middle attackers intercept these three channels at three different times in three different places. It's impossible, right? So this is a more secure system of encryption than anything that exists today in the world. So this is the of course it could be adapted to, in this example I'm describing with the plane and the ultrasound. It's an extreme example, right? The kind of things that a person in my situation has to do. But this can be adapted to a network protocol, right? Like, I mean, this technology that I invented can be used for a more secure network communication protocol than TLS and all that, right? That relies on pre-sharing the key for a secure session, secure quote unquote, because it's obviously it's not secure. Right? But you see, this this is nuclear, right? So of course I filed this patent application yesterday, and I sent it to. I sent a copy of the patent application to the EPO, the European Patent Office. So they also have a record. Okay, but here's where things get really interesting. And I mean, I think this is kind of it's a bit ironic and it's a bit funny at the same time. There was an incident that happened around January 31st, 2024. So I'm talking more than 2 years ago, right? And in this incident, what happened was, it's a long story, and I described this in a demo. There is a demo that is exclusively talk about this. It was recorded maybe 6 months ago. But they were attacking my servers using Akamai. Okay, and Akamai is a content delivery network, a big one, that services many of these companies that are controlled by the network, right? By this frequent enterprise in the ways that I described before. So they were attacking my company with Akamai, and so I noticed, I realized that the IP addresses of the attackers were Akamai IP addresses, and I was an Akamai customer at the time. I was paying Akamai for their services, which I understand now, right? It was they got me to do this so they could get all the traffic from my website, and they could attack it more easily, right? But anyhow, when I see this happen, I created a support ticket and I asked to talk to the Chief Data Protection Officer, a gentleman by the name James Jim Casey, or Casey, I don't know how to pronounce it, Casy. And he was former, before being at Akamai, at that position, he was the CEO of Neustar. And Neustar is also a very important company because they control basically the DNS infrastructure of the planet, right? So it's another aggregator that is important for this network. And he was the CEO of that, and then he went to Akamai. But anyhow, I created the ticket, and he starts engaging with me on the ticket, right? On this support ticket, him and the rest of the Akamai team included in a covert manner. Covered meaning in this ticket there were like 25 people CC in the CC field, right? And these were Jim Casey and a bunch of technical people. Right? So what Jim Casey did, was that he included into this long CC list, at the end of the list, he included a gentleman by the name David F. Hine. But he did it covertly. What he did is that right? Because this obviously included planning, and to make this happen, it requires work. This is not happen by accident, right? So the email address of David Hine, in the label of the email address, it said work, WORK in lowercase. That's all it said. It didn't say David. It didn't say Hine. It didn't say Boris. It didn't say anything, right? I've noticed because I saw the email and I inspected every single email to check who was in there, and I saw there was an email that was not an Akamai email, and it said boris.com. So I go and look what is Boris.com. Surprise, surprise, it is an intellectual property firm. And this was in 2024. I haven't even captured the database that Diosdado Cabello leaked to me, right? So even 2 years ago, they were already attacking me with intellectual property attorneys, right? And I knew this in 2024, and this is why I tried to contact the FBI in 2024, and I also described this in a previous demo. And of course, I understand how they blocked me, because these people in the intellectual property firms used to work for the FBI, right, and for the DOJ. So of course, they had a way to block me. Right? That's how they inserted Agent Cody and Enrique Morales into the equation, right? Because they have contacts at the law enforcement agencies, right? Because they were from the DOJ, obviously. Right? So, but anyhow, what I'm telling you is that Akamai in 2024 was directly attacking my company, my servers, and then they inserted an intellectual property attorney covertly in the email thread. Now, the thing about the work, the nomination of the email is important. Why? Because this implies collaboration directly from Boris, because the only entity that can set that label is Boris itself, the law firm, the IT department of the law firm. I mean, for the label work to appear in that email thread covertly in that way, necessarily the IT department of Boris or David F. Heim himself had to make that change. It's not possible for Akamai to make that change. So, I mean, this shows collusion between David F. Hine, Boris.com, and David F. Hine and Akamai, right? And Jim Casey. But that's what they did, right, in 2024. But now, this is, of course, a nuclear weapon for me. I mean, it's been a nuclear weapon forever. But now that I have, now look at the board now, right? That was in 2024, right? And I tried to contact the FBI and they blocked me, right? But that was in 2024. But now look at the board in 2026. I have these patent applications going. I have particularly this one about encryption. And I have the evidence of the attack and the collusion of 2024 between Boris and Akamai. And Boris.com is an intellectual property firm that at this point I have evidence that there is a serious statistical anomaly of the concentration of former DOJ officials in these type of firms as partners. And importantly, Akamai relies on encryption for everything they do. Because they have to provide secure communication for their clients. Because I mean, it's a I don't want to get too much into the details of what they do, but it's a service that allows internet companies to serve their traffic faster. But then it needs to be encrypted, right? So when you go to Google or when you go to eBay, for example, who's really serving you the content is not an eBay server; it's an Akamai server acting as a proxy. But they need to be able to encrypt that content to your browser. So this uses encryption. So this gives me an opportunity to put them on notice about this invention, right? I mean, to notify their legal counsel and to notify their intellectual property attorneys / former DOJ officials that are helping them, right? Including Boris.com, which is the one that they inserted covertly in 2024. So, I mean, this is nuclear, right? So this is exactly what I did. I sent them a notice of obsolescence, telling them that their product is going to be obsolete because that encryption is going to go away. And they're going to have to license the invention from me. And in that notice, I attach the copy of the email thread in which Jim Casey added David F. Hine in this covert manner. So I'm attaching the evidence of a crime into a legal notice that they're obligated to process. Legally obligated. And also they have the obligation to disclose this to the SEC. And in the same thread, I also attach the reports that the formal referral for criminal activity, wire fraud, and other, silencing a whistleblower and things like that I sent to the Honorable Cody Matthew Hirsch and the Honorable Colin McDonald at the DOJ. So, I mean, it's this game over, right? Because they have to respond. They cannot ignore me. I mean, they could, but it will just basically prove we are all in it, right? If they ignore me. No, so now they have to process it, and if they process it, it's game over, right? So that's what I did. Now I also sent a similar notice to other important networking companies, specifically Cisco Systems, Palo Alto Networks, because they also rely on encryption, right? And that encryption that they're using is insecure compared to this thing that I described. So I also send the notices to them. And I also sent it to Proton VPN, right, which is an important part of the attacks that Liana Technology does against the search results to suppress the websites of all the competition in the world. And that is the third leg of the criminal enterprise, right? So the first leg is the financial aggregators to take the voting shares in the public companies using the investment money of Americans. The second leg is the intellectual property firms, uh, you know, patenting all these inventions that they steal and putting them in the public companies to use them as aggregators of intellectual property. And the third leg is Liana Technologies, which is used to basically suppress uh, every possible competitor there could be, right? So, they steal your inventions and they make sure you never make money because you cannot get any exposure on any search engine, right? So, I mean, that's how they control everything, right? That's how they create the monopoly. They steal the inventions and then they suppress the competitors financially by not allowing them to have any exposure. And of course, at the same time, they also use the intelligence services of the other countries, so, Russia, China, Iran, Venezuela, and Cuba, um, to harass the technologies that are trying to do something, right? And, you know, the romantic partners and all that, like kidnapping the children. Like if things go south, they kidnap the child, right? So I mean, this is I think at this point, I see this and I feel like I have the complete picture. Like there's little mystery to me at this point on all this. So it's it's an interesting turn of events. Really. Give me just a second. Oh, sorry. This guy, XSS0304. Okay. Yeah, so let me review here where we are. So I don't know, maybe this is a good time to give you the notable players, right? That I've been looking at. So I mean, this is important to give you an idea, right? To give you an idea of the level of the people that they employ as partners in these firms, right? To do this, because it correlates with how easy it is for them to obstruct justice at the DOJ or at other places, like the SEC and things like that. And by the way, I sent all of them. I mean, at this point, I've sent over 400 emails to partners in these intellectual property firms in using this technique that I described, like putting them on notice that their clients are going to have a problem, right, because of these inventions. Um, so, for example, I'm going to give you just some examples, okay? So, for example, BlackRock and Lockheed Martin use a company called Munger, Tolles, and Olson. Okay? And in that company, uh, sorry. Before that, there is Ahmed J. Davis from Fish and Richardson. This is one of the important ones. Going back to BlackRock and Lockheed Martin, they use Munger, Tolles, and Olson. And in there, they have a gentleman by the name Donald B. Verrilli Jr. And he was the U.S. Solicitor General uh, and was also Assistant U.S. Attorney. So, the U.S. Solicitor General, that is a very high level position in the federal government. And so this person was that, right? And now he's a partner in this intellectual property firm. Also on Boris, on Boris.com, the legal name of that company is Boris, Sutter, Seymour, and Peace, LLP. And there they have Benjamin J. Glassman. And he was the United States Attorney for the Southern District of Ohio between 2016 and 2019. They also have, for example, John W. Spiegel, who was the Assistant U.S. Attorney for Los Angeles, where Travis Kalanick and Robert Gates, have their homes. You also have Daniel B. Levin, former Assistant U.S. Attorney. You have also Jonathan Kravis, who was also a DOJ staffer. BlackRock also uses the company Kirkland, and this one is tremendously important because it acts as an aggregator of intellectual property. So I don't know, it seems like they're packaging, bundling together. It's like they're doing the same with the intellectual property as they do with the mortgages, right? They're bundling them together into huge packages of intellectual property. I don't know how they transact with them, but they're creating like these packaged products with the and Kirkland. They're consolidating them basically, right? And Kirkland, this firm, is part of that effort. And there they have Matthew Galeotti with 2 T's, and he was a former acting assistant attorney general. Imagine that. BlackRock also uses another firm called Skadden with 2D, Arps, Slate, Meager, and Flom. And there they have Donald Vieira, um, who was a National Security Division official. And they also have a gentleman by the name Todd Patterson. But this is from Patterson and Sheridan. It's a different firm. Okay, another thing I want to tell you is that in this process, I figure out why the clerks do what they do. Right? It seems to me like they reward the clerks by giving them partnerships in these intellectual property firms. So that's the career progression in the RICO enterprise. If you are a federal clerk and you do something important for the network, you may get a partnership at some point in one of these intellectual property firms. Like there are a lot of these partners that were at some point clerks in the federal system, but not any clerk, like important clerks, like clerks to like the law clerks of the justices in the Supreme Court, right? Things like that. I mean, not the current ones. Like I found examples of people that were clerks of Supreme Court justices in the 90s, and are today partners in these firms, right? And there's a firm called MTO, uh, in which 75% of their lawyers are former clerks in the federal courts. So I mean, they're obviously concentrated on the clerks, right? And it seems to me like they reward the clerks in this way, right? If you, uh, if you work for the network, then at the end you get hired and you get. Okay, so BlackRock, keeping with the BlackRock battery of intellectual property firms, and like here you can see, right, that this is really a weapon because, I mean, supposedly these companies, BlackRock, Vanguard, and State Street, are investment companies. I mean, they should be focusing on investing, right? Investing for the investors. Like they should be focusing on buying and selling stock. But you can see here the concentration of IP firms that BlackRock is using. I mean, they probably have more IP firms than they have economic firms, and this doesn't make sense because they're a financial company. They should be having a lot of more economic consultants than IP consultants. So I don't know. This shows you that the real goal here is to get the intellectual property, and again, it's because the intellectual property has a value that exceeds the GDP of the United States. That's the reason, right? It's gold, and also it's a kind of gold that is it's not exhausted. It's a renewable resource in the sense that it's not like oil, right? That after you burn it, it's gone. The intellectual property, you can keep siphoning money out of the economy for 20 years or something like that, right? As long as the patent is live. Um, so anyhow, in this other firm, Oric, Harrington, and Suckley, which is an intellectual property firm that works for BlackRock, they have Josh Rosenkrantz. It's spelled Rosenkrantz. And he was a clerk in the Supreme Court of the United States so he was the clerk to the Associate Justice William J. Brennan Jr. And his brother, a gentleman by the name Nicholas Quinn Rosernack. I mean, I'm talking about the brother of the former clerk. Right? His brother, um, he had a prominent role in the U.S. Department of Justice. He served as an attorney advisor at the Office of Legal Counsel, the OLC, from 2002 to 2004. And they also have in that firm a lady by the name Amy Walsh, and she was Assistant United States Attorney, AUSA, in the Eastern District of New York. Also, I have to tell you, Lockheed Martin, this defense contractor that I talked about before, they have a huge overlap in terms of the IP firms that they use with BlackRock. It's basically the same firms. I mean, that's not a smoking gun, but I mean, it's a lot. It's a big coincidence, right? Now on Lockheed Martin, I have to tell you, when this network, this Rico Enterprise, moved me, and I documented this in one of the demos before. I'm not gonna go into the details, but they moved me from California, from Canada, where I was living at the time, in 2008, to California, using a job offer they made to me from Yahoo. So they lured me to California in this way, right? When I arrived to California, I started looking for a place to live, and Elena Nilsson, who is an agent of this network, she insistently suggested an apartment complex that was right in front of Lockheed Martin. And, she wanted me to get that apartment. I didn't get it because I thought it was too expensive for me. I can't recall the price, but at the time, I thought it was too much, right? And I didn't take it. But she was adamant that that was the apartment that I needed to take. But I didn't go for it. And it was right in front of the how do you say that, of the headquarters of Lockheed Martin. And I think there's design behind that. Like at this point, looking back, I think it would have been very convenient for the network if I had been in that specific geographical location. It would have made things easier for them. I think it's so I imagine their targets in that apartment, and this headquarters is the one that is next to the Yahoo office, which is at, if I recall correctly, is the address is 701 First Avenue, Sunnyvale, California. So right in front of that, there is a Lockheed Martin headquarters or offices, and that they are right behind a NASA hangar that is over there. You can't miss it. It's a huge facility. Another firm that they all use, I mean, this cluster of Lockheed Martin and BlackRock, is a company that the website is queenemanuel.com. And it's also an important company. Now, I have to tell you, there's an anomaly here that happened. That is the following: when I started sending these emails, right, at some point, at this point, I have sent something like 400 emails to partners individually, right, putting them on notice of one or multiple of their clients that they could be affected by these inventions, right, that I described before. Out of the 400, I only have gotten 2 replies, which is on itself a statistical anomaly, because like these lawyers, I mean, they're intellectual property attorneys, and they're seeing this huge portfolio of 50 very impactful inventions. And remember, I have the pedigree to be talking to them because I was employed by Google as a software engineer for, I don't know, almost 9 years. And I also was employed by Goldman Sachs as a managing director. So I mean, you should at least consider it, right? Like giving me a quote. I mean, I'm offering them business, right? And 400 of them, and nobody replies, right? The only one that replied was queenemanuel.com. But it's interesting because the email they chose to reply to was an email in which I had made a mistake. Because I'm sending these emails at high volume, right? I could make a mistake, right? Copying and pasting, right? The content of the email. So I made a mistake, and I sent the email to a group of partners at queenemanuel.com, but in the salutation line, I made a mistake and I copied the line from a previous email. So meaning the names in the salutation line did not match the names in the recipients, right? I mean, did not match the emails. So they choose to reply to that email specifically. They didn't reply to any of the other 400 emails, but they replied to this one. And what they replied was just a very short sentence that says, "We can't represent you in this matter, dot." Nothing else, right? "We can't represent you in this matter." 7 words, right? They didn't say why, but I imagine, right, if they get questioned by the DOJ, they will say, "Oh, we couldn't represent him because the salutation line made it clear that this email wasn't addressed to us," right? So they're going to say that, they did their due diligence to look at the email, but it wasn't addressed to them. So therefore, they stopped reading. They didn't read the notice, right? But of course, the obvious question that I would ask if I was the DOJ, right, is, okay, but what about the other 10 or 15 emails to the other 10 or 15 partners that he sent that were correctly addressed, right? Why you didn't reply to those, right? Anyhow, that's probably what they're planning. But when they did this is a mistake, because they engaged with me. And by engaging with me, I then replied with a notice acknowledging the error in the first email, correcting it, addressing it to the right people, and then proceeding to tell them that they are on notice because they're engaged. And a notice to the agent is a notice to the principal, right? Meaning that their client is considered now, legally speaking, to be on notice, right? So they made a mistake by replying to that email. But, and they also tested that, I guess, right? That now they know that I'm going to apply the notice to the agent is notice to the principal every time they reply to me. So they can't reply, really, right? Because then those companies are going to be bankrupted. So I don't know. It's a stalemate, basically. They can't move, right? They can't move, and not moving shows collusion. So it's really checkmate, I would think. but let's see what happens. Um, so I don't know. Let me keep going. Um, yes, yeah. So the obvious question for me here is whether this silence of more than 420 partners. These are not low-level attorneys or clerks. These are partners at these firms. That many of them happen to be former DOJ officials, and in these notices, I'm attaching the formal criminal referrals I sent to the DOJ. If a former DOJ official sees these criminal referrals, they have to act, right? So the question I have to ask is whether the silence from these 400 plus former DOJ officials slash partners at intellectual property firms could be considered as a concert of the mind. The concert of the mind is a concept in RICO litigation that, well, if you're conspiring with somebody, if you are in an agreement to commit a crime or to not act on something that you should have acted. So it makes me wonder, right, if this could be enough to show concert of the mind. Um, Let me see what else I have here. Yes. So now I'm going to transition. So I don't know this part. I think it's. I'm gonna like stop talking about the patent applications and the IP firms. But I wanted to give you that context. And by the way, all these emails that I've sent and the receipts, like I have a system that gives me when a receipt when they open the emails. All of those are available for download, and I'm gonna post them in a link in the agenda of this segment, and also I'm going to post them next to the video, uh, so you can download them if you want, right? And you can see the emails, and you can see who was contacted and the receipts, who opened the emails. But now I'm gonna transition to more observation things, right? Observational things more on the ground. Like this was like high level. And I'm gonna transition to more observational things, and then I'm gonna go into the technical topics. So the next item I have is a thing that happened with the State Farm. On March, I think it was March 3rd or March 4th. Don't quote me on the date, but early March 2026. They caused an accident when I was going to file a document with the Supreme Court of the United States via FedEx. I was going to send the package to the clerk via FedEx. So what they did, because they got desperate, they crashed into my vehicle. So I could not go to FedEx. Okay. Um, so of course, they dispatched a couple of police officers. It was a bit. There was a bit of harassment in the incident, but the important thing is that then the agent that crashed into my car created an insurance claim. Okay, and I got contacted by the insurance asking me to to file a declaration. But remember, I had talked about that accident, this quote unquote accident. It was really an intentional incident, but I had talked about it. I had described it in detail in demo or declaration D120, 120. And in that declaration, I also talked about Sinere Strain at Goldman Sachs and my experience with her at Goldman Sachs as her employee. I was her direct employee. So I talked about those two topics in that demo. So what I did, and I published this declaration in my book. So what I did to respond to the insurance claim, of course, is that I took the transcript of that declaration and I attached it to the insurance claim. Like saying I'm not going to, repeat everything I already said. Here's the transcript, right? But this transcript contains my declarations about Sinera Strain and my experience as her employee at Goldman Sachs. And I was a managing director at Goldman Sachs, and she was a managing director too, but she was my boss. So anyhow, I submit this to the insurance claim. The insurance claim, the insurance company, State Farm, and let me give you, I think I have here, let me give you the claim number, okay? Is 53-97, K as in kilo, 7-70, W as in whiskey. That's the insurance claim number with the State Farm. So, what the insurance did in response to this is that they didn't respond immediately to my email, right? But then, sorry, one second. They didn't respond immediately to my email. But then after a few days, he responded saying, I mean, the person, right? Brian something, I can't recall the last name. He said something along the lines of, I can't click on links on the email. So please send me this on a printed copy to this address. And he gave me a P.O. box. So of course, I mean, I've been dealing with this network for so long that I know what he's doing. He's trying to force me to file this on paper because a paper copy can be lost, misfiled, truncated. There's many things that could happen to that paper copy, right? And there would be no audit trail. And he's basically creating a written pretext to say that he did not process the declaration, right, that I had attached. So I replied to him saying, listen, please, I understand what you're doing. You're asking me to file something in paper so it can be lost or misplaced because it has this declaration attached that talks about Goldman Sachs and Scenario Strain. So I asked him explicitly to not treat my claim any differently than he would treat the claim of anybody else. Because, I mean, he was the person in the first place that emailed me asking me to email him this document. I mean, he gave me the instruction to email it to him. But then he's changing his mind and telling me that he cannot click on the attachment, right? So I mean, obviously he's changing the procedure because he initiated the procedure, not me. So why is he changing the procedure now? Because he saw what it contains. So anyhow, I wanted to give that piece of information because and this is important because those insurance records are pretty permanent. They can't delete them, right? And they have to be compliant with federal regulations. And state regulations on insurance. So, you know, that declaration is going to live there for at least 7 years. So when this implodes and, if somebody from the DOJ wants to know more about Goldman Sachs and what happened there and their connection to the Venezuelan intelligence, please, all you have to do is go to State Farm and ask them for the claim number 53-97 K7-70W, as in whiskey. And then you will get, the answer. The next note I have is that obviously, right, looking at all these, all these things that I've uncovered over the last week, it's obvious to me that the Goldman Sachs IPO team has to be in it, right? I mean, it has to be a fundamental part of this network for two reasons. Number one is that they are basically the factory of CEOs. The same way as Greg Abbott is the factory of judges, right? The reproductive organ of the judges. The IPO team of Goldman Sachs is the reproductive organ of the CEOs because they can create a new company by doing an IPO, a new public company, right? And this creates immediately a company with $1 billion capitalization and a new CEO/CFO that can then be captured by Vanguard and BlackRock and State Street. You see? So that's one of the reasons. And the second reason is because obviously the RICO enterprise is the intellectual property theft using the intellectual property firms slash DOJ alumni. So it makes sense to have the intellectual property teams in these finance companies that power the IPO, that enable the IPO, because, when you're going to do an IPO for the SEC to approve it, you have to have an analysis done by a company like Goldman Sachs. There are other firms that do this work, but Goldman Sachs is a very prominent one. So I'm guessing that, the IPO team at Goldman Sachs has to be part of this. Also, I have to tell you on this, when I was employed at Goldman Sachs, in the floor where my desk was, there was a space that was very interesting. It was the space of the IPO team. So it was a space in the middle of the floor that had it was a closed space made of glass, but it was like tempered glass, floor to ceiling. It was like a space within a space, something like that, right? In the center. And it was tempered glass there was only one way, right? They could see outside, but you could not see inside. You could not see who was inside. I have to tell you, the 2 years I was at Goldman Sachs, I never saw one soul enter that room. For some reason, it never happened that I saw one face. I don't know why. But Scott Weinstein and Shinera Strain both told me in different occasions that that was the IPO team, and that the reason why they had that one way, uh, window walls or glass walls was because they were a super secretive team, because they were working on things that were confidential, because these were IPOs that had not happened yet and they could move the market, and therefore they had to protect the privacy of this information. That's what they told me. Well, no, I think it's interesting, right? But uh, that, within this super high security environment, they had an even more secure environment, and was, surprise surprise, the IPO team, right? So I mean, it's obvious to me that the IPO team is a big part of this, right? There's no other explanation. The next thing I have is about the orders on the 387 core, and here I'm gonna get a little bit more on the ground, right? So this is the 387 core, Josh Telfair, George Bell, that had been harassing me with this, quote unquote family case for a year at this point, more than a year, and that have my son kidnapped, right? And they have this TTP in which this tactic, technique, and procedure, where they basically create an order, a void order, where they can, where they don't have jurisdiction, or without giving me due process, without even calling me to a hearing. They create a void order like that, and then what they do is that they create multiple versions of that order, 2 or 3 versions in some case. And then they hide them using Tyler Technologies, which is a publicly traded company, part of this RICO enterprise of the judges, of the intellectual property attorneys, really. The owners of the RICO enterprise on the legal side of things are the intellectual property attorneys, right? So they are the bosses of Telfair and Richard Bell. They command them. They gave them orders, right? So they create these multiple versions of the orders, and the idea is that depending on who asked for the order, they give a different version to a different person, right, or entity. So if I ask for the order, they give me something that it's not really an order. So I don't think that I'm in danger, right? If the DOJ asks for the order because they're auditing or questioning them, then they will give them an order that is perfect. And then if I try to appeal the order that they gave me, they will use that appeal to call me crazy because it doesn't match the real order that they have hidden. You see? So it's a way of basically discrediting me as well, because my appeals will not match the order that they're hiding. So anyhow, the mistake on this is that, and there's a mistake that they made, is that they had to serve me according to the Texas rules of procedures, because I'm a pro se litigant. They are obligated to serve me with a copy of each order, and they've never done this, right? They have to physically mail me in a physical letter the orders, and they never do it, because if they do it, I would have proof that they're switching the orders. You see? So this just proves that they're doing this intentionally. And I'm going to give you the case number here and some examples. So the case number is 25-DCV-328122. And if you're the DOJ, what you have to look for is index number 7, index number 8, index number 70, index number 62, index number 77, and index number 82. These are all examples in which they do this thing where they create multiple versions of the orders and then they hide them from the document. But then you see that after these orders are there is no notice to proceed litigant issued by the clerk. And then you will see collusion between the clerk and the judge, right? And the attorney and the opposing counsel. And as I said before, these clerks then get rewarded by getting jobs as attorneys in the intellectual property firms. Right? That's basically the career progression. Let's see what else we have. Yes, the next thing I have is that I mentioned this in the previous demo. There is a series of zip codes that are important hubs for this RICO enterprise of the intellectual property attorneys / judges, former DOJ officials, that those zip codes form a very precise, a straight line on the mid-Atlantic region of the U.S. It's basically splitting the country in two halves. The headquarters of Vanguard falls in one of these important zip codes. I mean, I'm just telling you this as an observational data point to show you that Vanguard is an important piece of this. And the link to this data is in the agenda of this demo. The other data point I have is that I figure out, there was a question in my mind for a long time, is why there was such a high concentration of points in the database, I mean geographical points marked in the database that Diosdado Cabello leaked to me in 2024, that fell in Iceland. It didn't make much sense to me because Iceland is a region that is not heavily populated. Like why? I mean, and if you look at the international arena, right? Iceland is not a place that figures as an important, you see things about China, about Russia, but you never see Iceland. So why are there so many important points in Iceland? I figured it out. It's because of this technique they have where they change the sign of the longitude of a place. Like the same thing that I described, like when you change the longitude of the house of Robert Mueller at Lake Point Estates, you end up with the point that is marked in the geoindex in a mountain in China. Or they did the same with the location of Letter Stream, the company that I use for mailing things. If you change the longitude of these points that are marked in this database of Diosdado Cabello that fall in Iceland, if you change the longitude, all those points fall in Switzerland. So basically, Iceland is the bizarro Switzerland. Right? Is the way they mark these points for crypto payments that are super secretive in a way that cannot be tied to people in Switzerland, right? Because they're putting the points in Iceland, right? But the bad news for them is that now this is a known and demonstrable pattern, right? So all the authorities need to do is look at these points in Iceland and see where they fall in Switzerland, right? And those are the people that have the crypto payments. Let's see what else. Yes, well, the last note, it's too obvious at this point, right? Like, I had a note saying, like, if I manage to get traction on the law changes that I'm trying to, um, to put forward, I imagine, and if the SEC, for example, if the SEC takes action to, to stop this practice of accumulating control over companies exceeding 10% of the voting shares without being considered an insider, if the SEC, for example, passes a rule change, I imagine BlackRock is going to sue the SEC on the Supreme Court of the United States. And they will probably be counting with the pieces that they have in there, like the clerks, right? For example, things like that. So, but I mean, at this point, it's too obvious to even say it, right? Now, I have to tell you two important things. Remember I told you about that Scolari article I wrote about I wrote two in reality, right? About the Rico Enterprise and the article for commentary that I sent to law journals. I also sent the book with the patent applications, all the 50 patent applications and the letters to the DOJ and all that. I also sent it to multiple journals, to multiple law journals, because intellectual property is an area of law, and they have a bunch of journals in Scholarica that are in that area, right? So I sent the two things: the book of the patent applications and also the article for commentary. Well, I have good news to tell you is that both got picked by a journal in Washington, a prominent law journal. I mean, this is a fundamental achievement for me because, well, first of all, I'm not an attorney, and my research paper in the matters of law and justice got selected by a law journal in Washington. And I have to tell you a little bit. I want to tell you a little bit about how this selection process works. Basically, when you submit these papers, you have to make the submission anonymous. So you have to strip or redact anything that could let the reviewer understand who you are. So I could not say anything about Google, about Goldman Sachs, my name, the case numbers, nothing, right? So I had to redact all that, and I did. And on the patent applications as well, I had to remove my name, my address, everything, right? And then they sent these submissions to multiple independent reviewers who are attorneys or technical people in the case if it's a technical patent. And the reviewers read it, and so this is peer reviewed. It's not a person, it's not an editor, it's not like a journalist making a decision. This is a peer reviewed process. So imagine what this means. It means that my allegations about the judiciary fraud committed by this RICO enterprise in the 387 court to have my child kidnapped and multiple children in Texas kidnapped. I mean, I'm not the only person they're doing this to. This got reviewed by independent reviewers who are trained attorneys, and they thought that this was something that was worth publishing in a law journal that publishes only once a year in Washington. I mean, this is not a journal that goes out every week. This is something that they do once a year, and they selected my article for publication. So imagine what that means. And imagine not what that means to me, but what that means for Judge Telfair, Judge Bell, and every other judge that is helping them, right? Uh, so this is, this is nuclear, really. Um, uh, One second. Yes. And also on the patent side of things as well, because this establishes even more my prior art. I mean, this and it also establishes the materiality of these patent inventions, right? Meaning, because the network, they could say, oh no, we thought this was a crazy idea, we didn't think it was possible. But I mean, if it's selected for publication by a journal that talks about technology in Washington, how can they say they thought it wasn't? It gives materiality to the inventions. I mean, it grounds them. Like it's not possible to say that you thought they were not possible to implement. Right? So I think this is going to be fundamental. So I'm going to close this segment here to avoid making the recording too long, and I'm going to record another more technical segment in a bit. Okay? Thank you so much. So this is the third segment of demo declaration 132. And so now I'm going to talk more about technical topics, okay? Like technical topics. So let's talk about um, yes. So something uh, that I put kind of a cryptic note in here, but I'm going to tell you what it is, right? So um, yeah, so this is something that I didn't know exactly how it worked, but the informant told me. And we're talking about the Venezuelan informant that works in the Venezuelan intelligence, army intelligence. So he gave me a tip. I don't recall exactly when this was. Maybe 2 weeks ago. I would put it about 2 weeks ago. Um, so he told me to look into, and he explained why, right? But what he told me was to look into. So my car, I'm driving the Tesla, right? It's a Tesla Model S, and it has this device which I know at this point that is basically an espionage machine that the Chinese use, that is installed behind the rear view mirror. Okay, and this device. It has a series of electronics inside, right? Like it has a camera and it has LiDAR sensors and it has also an infrared transmitter or emitter, like a LED, like an infrared LED, or an array of infrared LEDs, right? And I have recordings of this device emitting infrared. Um, but like long time ago, maybe 2 years ago, or maybe like a year ago, I concealed this device, meaning I put black tape on top of it to make it so that it could not, see or transmit anything. Um, because that camera, they can, for example, if that camera captures the plate of the car in front of me, and the car in front of me is an agent, and they know the location of that car by proxy, they know my location, right? And I explained how the system that they have works in another demo. Um, but what I want to tell you is that I concealed this device in a way. Not concealed, but like I blocked it. Like I put black tape on top of it. I made a square of black tape on top of the glass of the windshield, obstructing the view of this device, both in both directions. So the informant told me look into the black tape because we caught it at some point uh, months ago. So I go and look, and he was right. They what they did is it's kind of funny, right? Because I mean they're inventive. What they did is with I imagine with a knife or something like that, they cut a square on top of a part of the black tape that I had put. So I don't know, like to give an idea, this square of black tape that I made, that I formed with black tape, uh, was probably, I mean, I still have it in there. It's probably, I would say, maybe 15 centimeters by 15 centimeters, right? Um, I don't know how much is that in inches. I don't know, 7 inches. I don't know. But so what they did is that they didn't remove it because if they had removed it, I would have seen it, right? But what they did is that they cut a rectangle, like a small rectangle, inside of my square of tape. And because the square is black and the background of the device is black, it looks black. I didn't. I mean, for I don't know how many months, I did not notice that they had cut the tape, but they made a square, right? So the reason why they made a square is because they wanted this thing to be able to see and to transmit. And the informant told me this, right? So the informant told me how it works. I mean, basically, and he's not technical, but by what he told me, I understand now that really the vehicle, and I don't know, like I don't know if this is only my Tesla or every Tesla has these capabilities. I have this capability, I don't know, right? But at least mine has multiple listening devices, and it has multiple possible gateways. That's the way it's designed. So they have different methods that they can use to extract the information, the audio from the car. Um, it's not one, they have multiple possible avenues and they could use them in different situations, right? So they have a menu of things that they can do. So of course they have the radio frequency transmitters that I know are in the door handles, right? That's where they installed them. And they also have other ones on the back of the front seats. Um, but those are radio frequency. They also have the visual ones. So, for example, that device. Basically, what I want to tell you is that that device on the back of the rear view mirror emits infrared towards uh, towards the outside of the car, right? So the technique is the following: if a car in front of me has a rear view camera that is equipped, I mean, the technique is that the cars have a rear view camera that is equipped to see that frequency. And because the camera can see that frequency, they can get they modulate digital signals in the pulsations of that light. And they get it with the camera in the car that is in front of you. That's why I mean, and this is what the informant told me this part, right? This is why they always want to have a car driving in front of me. If I change lanes, the car will change lanes. Or they will bring another car to position because they want to get what they want to get is the flashes of infrared light with the rear view camera of the car that is in front. That is the goal. You see? Uh, They also have other devices that do the same. For example, that's the reason why they have the flashlight. So the headlights of my car are also equipped with infrared, and I have tons of videos about this because I have cameras in my home, and when I drive home, when I get to home, if I look at the recording, I can see the flashing. My headlights are flashing in the cameras because they are equipped with infrared, and also the tail lights, like the stop lights of the car on the back, they also have infrared lights that flash. But those flashes are not just like flashing lights, infrared. They are really modulating data. So those flashing lights that you can see in the recordings of my car, um, like if I ever post one of those recordings, if you, I don't know if you have seen them, but I posted some of them, right? And there is a recording of the day before my son was kidnapped, which happened on March 28, 2025. I happened to catch a recording of the black Tesla driven by Suleima Villamizar slash Gloria Espina, in which you can see the headlights flashing um, in that video, and it's posted on YouTube. Right? Not the headlights. In her case, it was the device behind the rear view mirror, what was flashing. Um, so anyhow, you can see there. But what I wanted to tell you is that the flashing of the headlights is not a random flashing. That flashing can encode data. If they activate that feature, they can extract the data of the car the audio that they're recording of whatever I'm saying from the headlights. That's why they want to position a car in front of me. So so the headlights flashing patterns get recorded by the rear view camera of the car that is in front. And the same with the tail lights. That would get recorded by the Chinese espionage device behind the rear view mirror that is installed on the car that is following me right behind me. So that's why they have to have a car in front of me or behind me. But there's also something else the informant told me. They have a mechanism that is controlled by this espionage app that is basically a clone of Uber weaponized, right? Uh, and the way it works is that, and this is one of the most secure way of infrared communication that they have using this infrared technology. Basically, the technique is, and this came from the informant. And of course, I put the tape back on where they cut this rectangle. I put tape again on top of it, right? So now they're forced to use the headlights or the tail lights or the radio frequency, which is worse, right? Because the radio frequency could be intercepted by anybody that is nearby. So in terms of security, I think the tiers are the radio frequency that is in the transmitters, right? The radio frequency transmitters that are in the door handles of my car are the least secure because they could be intercepted by anybody that is nearby in any direction. They're omnidirectional. Then the next level of security is the headlights or the tail lights because that could only be intercepted by somebody who has a camera to see infrared and that has the technology to demodulate the flash, right? Which probably encrypted. And the third level of security is the most secure, which is rear view mirror to rear view mirror. So if you have two cars driving in front of each other, right? And one of the cars is emitting the pulsating signal using the rear view mirror device, and the other car is recording it using the rear view mirror device. So the cars are front. Imagine that, right? The cars have to be facing each other. In that situation, that's the most secure way of communicating, because it's not only infrared, but it's also very directional and short range. This pulsating light emitted by the rear view mirror device, it has low intensity. It doesn't reach. It's not like a headlight, right? The headlight could reach 150 feet, but this thing is just, I don't know, 20, 30 feet, right? And it's also very narrow and very focused. So it has to be directional. So you have to be pointing it to a specific place. So this is why, and he explained this to me. He explained that this is why some of the corners where they do this frequently have a shape that looks like an S. Like if you look at a road and you look at a curve, there are different shapes that the curve can take, right? So a regular a regular curve, and I wish I was doing this on the computer because I could show you some examples, but if you think of a regular curve on a road and you have two cars traveling on opposite directions, these devices on the rear view mirrors will not align. Um, See, here's an example, right? So this guy comes with the phone to record what the thing is saying. Um, but so if you have a regular curve in a road, these things will not align. I mean, the devices that they have on the rear view mirrors on the two cars. Why? Well, because as one car is entering the curve in one direction, right? The angle, I don't know, try to picture it, right? So imagine that you have this put on a piece of paper, right? And you have a curve that looks like a U, right? So if one car enters the curve in one direction and the other car enters the curve on the other direction, you will see the two devices will not align because they are mounted flat on top or behind the windshield. But replace that scenario with a curve that looks like an S, right? Where you have like two curves combined, and it's like an S. It's shaped like an S. In the exact middle of the curve, the two cars will be parallel by pure logic, right? And the devices will align. So this is why that curve at Lake Point Estates have that shape. There are a couple of curves at Lake Point Estates on the two sides of the neighborhood that have this exact S shape that I'm describing. One is close to my home, and the other one is close to the home of Phil Denning, right? So, I mean, this is the most secure way of communication they can do because it requires not only proximity but also directionality and short range and infrared, which is not visible by the human eye, and it's also encrypted. Right? And the encryption key depends on the location. I mean, so this is very secure. But I'm telling you this, well, first of all, to tell you that I think the design of Lake Point Estates, I mean, these S shapes in Lake Point Estates, and I'm telling you this because of the data that I have, obviously, this was designed for this, right? This is not random, right? But at the same time, it's also a weakness because this is a signal for detection, right? So what if you are the FBI? What I would do, or I would recommend, that you could look into is trying to see if you can find gated communities that are marked in this database of Estado Cabello that have these curves in the roads that have shapes like an S. And the important agents have to live close to the S's, but not on the S's, right? Because they wouldn't want the important agents to be exposed to this traffic of cars exchanging data. Like it would be a risk, an unnecessary risk. So, I mean, the ones that live close to the S's are people like Phil Denning, like the operational people that are looking after the important people. But Robert Mueller doesn't have an S in his road, you see, or Terrell Miller, right? And again, talking again about Terrell Miller, the reason why Terrell Miller lives in the road that has no S in the road and he has the most expensive house is because he is the intellectual property attorney. And the intellectual property attorneys are the bosses in the RICO enterprise. Like they are the capos, basically. Right? So that's why he has the $4 million house and not Robert Mueller. Uh, well, also Robert Mueller, it would draw a scrutiny, right? If Robert Mueller is probably a billionaire because of he has the governmental crypto payment wallet, right? But and I described what this means in a previous demo. But uh, so he cannot be drawing attention by having a $5 million mansion. But uh, uh, the Red Miller can, right? And but I think these two data points that he has the most expensive house and the least inconvenient street that doesn't have the exchange point for the most secure way of communicating. These two things combined tell me that suggest to me that the capos are the intellectual property attorneys really. So that's the thing about the S. So if you are the FBI watching this spectacle, what I would recommend is to equip your cars with infrared cameras, right? And you will be able to see the flashes in my car. from my car, and then you can work it backwards. And I mean, I'm going to start trying to decrypt it, but I haven't done this exercise with the infrared, but I'm sure I will be able to, because I decrypt the things that they send over other channels. So there's no reason for me to think that I cannot decrypt this. But if I can decrypt it, you can probably decrypt it too, right? I mean, you surely can decrypt it. You have more computers than I do, and more people. Right? So all you have to do is equip your cars with infrared cameras and record the sequence of flashes in my headlights, my tail lights, and from that device that, well, right now I have it blocked, right? But you can also look at the device that Gloria Spina slash Suleima Villamizar has in the black Tesla, because she has a similar device. And they must have her under surveillance all the time in case she gets she makes a mistake, or I mean they have to have her under surveillance, right? They must. Um, so you can also get the flashing lights, the infrared lights, the signals from her car, um, the black Tesla, and that black Tesla is registered to my name. So you can just look the registration under my name, and you will find the car. Um, let's see what else. Yes, the nail. So this is something that happened. I think it was last week, right? I was working on some patent applications, and I saw that John Miko, my quote-unquote neighbor, uh, started again with the thing of sending flashing light transmissions to Joel Gray's house as I was filing a patent application at 5 a.m. Because it's night, I can see, right, in the cameras. I mean, I can see the flashing lights. But this told me that he must have been sniffing the uplight again, because he was doing this before, but then I took some measures to cover where he could get the signal from. And then he did not the transmissions anymore, because if he cannot sniff the signal, he doesn't know when I'm transmitting, and therefore he cannot do this when I'm doing something with the internet. So the fact that he was doing the flashing sequences at the same time that I was trying to file the patent applications told me that he must have found a way to defeat what I had done, the way I had covered the, the the antenna and the. So I go and check, and yes, so there was a nail that is. I think they put it in there. I don't think I put that nail myself, but it's a nail that looks like the nails that I put. And it's positioned in the. So I described this before. I constructed a vault made of wood to cover the antennas to make it harder for them to intercept, right? So they put a nail in one of the wood planks that is positioned exactly where the feed horn device of the antenna is. But it's like, it's like it's obvious, right? Like the nail is basically almost touching the feed horn device. And I think what's happening is that this nail is made of a material that causes reflection of the signal. And then the signal escapes the vault. It goes in all directions, and then they can sniff it, right? So what I did before is that I had covered the nail with a metallic material to make it so that the radio frequency energy cannot hit the nail. When I did that, he could not do the flashing transmissions. I mean, I could not see the flashing transmissions when I was active with the antenna. So I thought, I defeated this, right? But after a week or so, it started again. So I went out and checked, and yes, the nail was uncovered. So basically, what he's doing, he's jumping over the fence somehow and removing whatever I put on top of that nail to cover it, right? So they can again sniff the signal. So, but I mean, at this point, well, first of all, this confirms, right, what they're doing. That John Miko from the 2310 Britton Ridge Drive, Katy, Texas 77494, is actively sniffing this antenna. Secondly, it confirms that they're after the patent applications, because he does this when I log into the USPTO website specifically, right, or my bank. Those are the two things that they can't resist. And authorities can cross-reference what I'm saying with the times I've logged into the USPTO website or the bank with with the recordings of my camera system, which are time stamped, and you will see that it's exactly the way I'm describing it. Well, and the third thing that this confirms is that he is jumping over the fence to uncover the nail to then be able to sniff the antenna. So it's at this point. I mean, it's so obvious exactly what they're doing that you know, I know exactly how not only what they're doing but how they're doing it. So I don't know. It's just at this point, it's funny, and the funniest part of all this is that I'm defeating them at their own game. Like I'm defeating the intellectual property attorneys, partners slash DOJ alumni using patents. I mean, it cannot be funnier than this. Uh, I mean, I could have defeated them in any other way, but I'm defeating them with the thing that they do for a living. I mean, this is hilarious. Uh, uh, but I think there is something. I mean, it's fun. It's hilarious to me. But I think there's something more profound here. Is the communist paradox, right? Is that these people are not good at what they do. I mean, the technologies, and I don't know. Like, let me tell you something, right? And I'm not saying this to brag or to, but it's something that is really, it's a really fundamental thing here, right? Think about it for a second, right? Like, for example, the encryption technology, right, that I described. These people have been working and defeating encryption for 30 years. How is it possible that nobody in their companies thought of this simple logical technique to make encryption unbreakable? I mean, it's either that they, you know, didn't want to improve encryption on purpose, or that they're incompetent. I don't know. But if they're incompetent, I don't. It's not because they're ill-equipped. It's because they have no motivation to work because they're stealing the inventions from everybody else. You see, and this is exactly the communist paradox that I described in my book. It kills motivation and it kills the innovative drive of the individual because all these people know that they can steal the innovations from everybody else, right? And they don't have to do any work. Uh, so I don't know. Yeah, it's just something to think about, right? Let's see. Yes. So that day that I discovered that John Miko had uncovered again for like the third time the nail uh, that is positioned next to the feed horn device of the antenna. On that occasion, I was trying to file the an application, right? And I'm going to tell you something that is a bit of a nuance of how I create these applications. But I used to put the names to so you have to create a PDF file, right, with the actual text of the patent application, the invention, the disclosure. Um, so I created um, right. So I created yeah. So I used to create before, right? I used to create a PDF file, and this PDF file would be named application dash and then the name of the invention, something descriptive, like I don't know, application dash uh, high radix communication system. Imagine that. Right? Anyhow, that day that I discovered that last week, that John Miko had uncovered the nail like for the third time, I was trying to file an application, and the USPTO website gave me an error that I had never seen. I mean, it never gives me an error. I filed until that point like 43 applications, right? But I'm going to file this one, and when I try to set, well, so when you upload the PDF document, you have to set the type. You have to tell the system what this document is. Is it a specification? Is it something else? Is it an appeal? Is it? You have to say, right? What is exactly that you're filing? So the the thing was when I uploaded this particular document, and I tried to select the type of the document, it would give me an error. And this error was such that the type of document was never recognized. I tried like 10 different times, right? and with different documents. I tried to file different patent applications for different inventions, thinking that it could be the PDF document that was faulty. It wasn't that. And it always failed in the same manner, right? So I started thinking, well, if this is a bug, it's a serious bug. And it's a serious bug in the US PTO system, right? So I did an experiment. I changed the name of the file. I removed the prefix application dash. Once I did that, the error stopped happening. And I was able to file all my applications this way. If the PDF file contained the word application dash, the process failed. But if I removed it, the file was able to pass and I was able to file. So you see, I think this was intentional. What they did, because they noticed I had filed at that point 43 applications, right? So they knew that all my applications had the file name, the PDF file, application dash, that I had that pattern, right? That I always put that prefix. So they created intentionally a bug in the US. This is a theory. I cannot prove it, but I imagine the DOJ would be able to. I imagine they created intentionally a bug in this system that when it saw the DOJ dash prefix on a file, it caused some kind of problem and the thing failed, right? Probably in an explicable manner. Like I don't think it's gonna say, if application dash then die, but like somehow they created a bug, right? That happened specifically when I put, and it's important that it's only in this case because otherwise multiple people will notice the bug and they would get in trouble, right? So it has to be tailored to me, but it has to be at the same time explainable and look not intentional. So, another thing I noticed is that before the type of document in this list of type of documents that you have to select from, before this type of document used to be called in the first 43 applications used to be called a spec in uppercase dash a specification. That was like kind of the line item uh, uh, denomination, right? But on this date, when this problem happened, this bug occurred, the name of the type of document was inverted. Now it's called a specification dash a spec. So the spec is now a suffix. Before it was a prefix. So I imagine if you look at talking to the DOJ, right? If you do a forensic audit on the code base of the USPTO system, I would look for a change in which this line item name was changed from a spec dash a specification to a specification dash a spec. And I would guess this is probably the code change or the pull request in which the bug that it was used to target me so I could not file more inventions, more applications for patents, was introduced. So, I'm just giving you a hint as an engineer of how I would look for who made this bug possible. Okay. I don't know. Maybe it helps. I don't know. Let me see what else I have. Yeah, so this is important. I also got this from the informant. I think it was Saturday. I can't recall. The informant told me that. Um, so last week, right? Suleima Villamizar slash Gloria Espina, she told me that she took the child to the movies. Now, the informant told me that this was a pretext. That really, yes, they went to the movies, but the real reason is that so she could talk to Andres Salvador Mendez because they haven't been able to talk for something like, I don't know, 3 months, and she was complaining too much, and they were afraid that she might deflect. So they set up an opportunity for her to see him after 3 months, or I don't know how long. So they did this at the movies. And the reason is because it's a controlled environment and it's dark, right? It's pitch black, and they have a record of who gets in and who gets out. So they could vet whether it's possible that the FBI put a person inside. If they see that the FBI has nobody inside, they go ahead, you see, and they bring Andres Salvador Mendez, which is what happened. Um, So they met there. But I think this could be a gold mine because I imagine, right, the authorities must have a way to see all the cell phones that were in that theater. And one of those cell phones has to be registered to the new alias of Andres Salvador Mendez. So it should give you a way to find the actual person behind the new alias, right? I imagine. I mean, the metadata is unescapable, right? That's how I always get them with the metadata. I know this from experience. With the metadata, I can easily get them, right? Like the former employment of the DOJ officials, right? Yes. Um, so let's see. Yes, and also this is important. The informant also told me that during that conversation on the movie theater, they were discussing uh, the possibility of running away. And of course, this is serious because this would mean kidnapping the child, right? I mean, kidnapping him again and in a more serious manner, right? So I don't know if authorities are listening to this or listen to this at one point. I beg you, please make sure that they don't kidnap the child in that way. Um, and to the intellectual property attorneys, I tell you that be careful with that because that would be a next level escalation in terms of criminal liability. So be careful with Andres Salvador Mendez and Suleiman Villamizar / Gloria Espina because they could put you in serious trouble. Uh, they are thinking of running away. Uh, yes, another incident that happened on April 5, 2026. I was submitting an application for a mass storage system using a high radix encoding and parametric system. When I was doing that, when I was filing that application, the agent that lives at the 2318 Britton Ridge Drive, and his name is Ejad, and so Ejad is the man, and the woman is Nushat Ahmed, Ahmed is the last name. They did a sophisticated sequence to intercept the cookie. And this is important because I think it shows collusion with the payment processor that works for the USPTO website, or that is the payment processing company that is integrated into the USPTO website. And this is important because the CCP controls all the payment companies, right? Online payment companies. So this is what they did. In the exact moment when I was going to submit the payment, they brought out of that house two different vehicles. One was a red Tesla Model Y, and the other one was a truck or a pickup truck or an SUV, I can't recall. But they brought them out at the same time, at the exact moment when I hit pay on the website. And the cars were standing there for a few seconds, right? And when they did this, the request to make the payment hung forever. It was hanging for like 3 minutes. It would just not go through. And this has never happened before. I mean, and at this point, I had filed 44, 45 applications, right, in total. And the payment request never hung. And it hung in this occasion when these two cars came out of the driveway. And remember, this car, if you look at them on 130, I think it is, or 129, I described when the informant gave me the information that this agent, Ejad Ahmed, had installed a huge canopy on the backyard provided by the CCP to intercept the downlink of that antenna. So, it's obvious what they're doing, right? They get the downlink with the canopy, they sniff the downlink that way, they isolate the signature of the transmission. And the reason why they had to move the cars was to position them in a way where they could impersonate the antenna. So they needed the angle, right? And where those cars were parked was exactly the hot corner of Joel Grade, which I've described hundreds of times in these declarations. So the reason why they brought the cars outside was basically to create the physical conditions, the geometry necessary to impersonate the antenna. And then they could pass their devices as if they were my Viasat antenna. You see? That's what they did. And this is a way for them to get the cookie. To then be able to log into the website as if they were me, to the USPTO, and download all the patent applications, or maybe file run documents. I don't know, things like that, right? But of course, when I saw that they did this, I immediately logged out, killed the session, so they cannot, even if they got the cookie, they cannot use it. And then I logged back in after. But this is important. I'm mentioning this not to complain, but because to know when I hit payment, when I hit pay on that website, the only way to do that is through control of the payment processor company. Or well, unless they put login on the USPTO website, but that would be too obvious because it would show that they're modifying the code of the website to track me, right? I don't think they're gonna do that. The easiest way, the most covered way, would be with the payment processor, but this would mean collusion between Ejad Ahmed, who lives 2 houses down the block from me, uh, and the payment processor, who is controlled by the Chinese. So, this could be nuclear evidence for the DOJ. That's why I'm mentioning that. So that information about Ahmed and the canopy and all that is on demo 126. I correct that. I said 130 before. It's not correct. The right demo where this information is about, when I was told that he installed that canopy, this was on demo D126. Yes. Another note I have here is about the CDNs, right? The content delivery networks that this Rico Enterprise have, like Akamai, for example, right? So, for example, Akamai is used by the SEC, the DOJ, the FBI, which is dangerous, right? And the CIA. It's dangerous because they can see who is reporting them because they're proxies. I mean, Akamai is a proxy. It's a proxy service. So the request goes through Akamai first. So if you make a report to the OFAC, the first server that gets a report is Akamai. So the Akamai knows, I mean, Jim Casey knows before the OFAC who's getting reported. You see, it's very dangerous. But the note I have here is about why is that the USPTO does not use Akamai. I mean, if all these federal agencies use Akamai, why the USPTO doesn't? It uses Cloudflare, which is a competitor of Akamai, and it's also controlled by this network. But there has to be a reason why they're keeping Akamai out of the USPTO. This has to be by design. There is a reason why they see liability if Akamai is the service provider of the USPTO. And I'm trying to understand what that is because I want to attack that. So, informant, if you are listening to this, please tell me what's the reason behind this thinking of keeping Akamai outside of the USPTO. Help me out, throw me a bone here because I'm taking no prisoners. Yeah, so this group of observations are very small, so I'm going to just go through them quickly. One is about the reverse age distribution. So this is basically in the societal systems that this network forms. This is just an investigative tip. You will see that there's two types of systems. Ones in which the individual at the top of the system is very young, too young to be in that position. Like, for example, uh, Parag at Twitter, right? Or Parag, the CEO at Twitter, right? That supposedly was fighting with Elon Musk, but they weren't fighting. I mean, they were playing together, right? But that's an example. Or the Chief Justice of the Southern District of Texas, right? That is too young to be. I mean, Judge Hittner is probably 30 years his senior, right? But the Chief Justice is 40 years old. Um, so you have those type of systems, and the other type is the opposite, where the individual at the top is very old, like Larry Fink. Um, so it seems to me, by doing a statistical analysis, that the way this is, I mean, it seems like there's a reason. I mean, I don't know. I don't know what's his thinking, right? There's probably multiple explanations for this, right? Corruptibility. I don't know. There's many. Uh, but it feels, from the statistical analysis I'm doing, that the systems that have the young individuals at the top, those systems are used for defense. So the job is to be inept, or to not do their job, right? Uh, to be ineffective by design. It's a way of obstructing justice, for example, right? Or making something difficult for the target. But the ones that have old individuals at the top, those systems are used for attack, like BlackRock, for example, or Vanguard, or so you get the idea, right? But it's interesting because it could give you an idea of, I mean, if you derive metrics, right, from the aggregate age of the individuals at the top of the system, you can estimate if it's a system used for attacking or for defending something. Um, the other thing I want to tell you, demo 131, I made a comment about CarMax at the end of the demo. And I said something like, oh, they're in it. And I didn't really explain why I said that. But if you look at the recording, which is posted on the Google Cloud Bucket, storage bucket, you will see that all of the vehicles on the back, which are hundreds of vehicles, all of them had license plates. And this is not logical because CarMax they sell used vehicles, and used vehicles in Texas don't have license plates because the license plate is tied to the owner, not to the vehicle. So when you sell your car to CarMax, you take the plate with you. So, and in the back of this depot that had a bunch of features, it's marking the index and it has certain characteristics that my system can pick up on. All the vehicles on the back had plates. So this means that they're really using CarMax, in that particular CarMax, as a car storage or rotating facility to anonymize the agents. That's why I say that. I made a note here about two important addresses. I can't recall exactly. I know one of these is because it's next to an immigration center that is important to them. That is next to the airport. But the other one, I can't recall what I put it in there. But I'm going to give the two addresses. If I put them in my notes, it's because they're very important, right? If they made it to this point, it's because they are important. So I'm going to give them to you. One is 7523 Finn Way Drive, Humboldt, Texas 77396. Finn has two N's at the end. And 13903 Alex Landing Drive, Humboldt, Texas 77396. And another one I have is 5142 Greens Road, Houston, Texas 77032. And this is World Houston 46, which I think is owned by East Group Properties. Um, and it has points marked both in the location and in a mountain in China. And I think this is the one that is next to the immigration center and the airport, um, if I recall correctly. Okay, and the last small note I have is that LinkedIn, the social networking company, they changed my name of my profile without me asking them, from Reynaldo Aguiar to Reynaldo A. And I believe this is a move to make me anonymous, right? So if somebody is looking for my last name, they don't find me, right? And they don't see that I was employed at Goldman Sachs. I think that's really the goal, right? To hide that they've been doing this directly, right? Uh, so I don't know. I wanted to just put that out there. So I think that's all I have for today. And with this, I'm gonna close this demo, and I'm gonna thank you for your time, and I'll see you on the next one.